But let me just welcome, Tino, Eugene, our small little group here to this founder roundtable. As you guys know, we do these every month. We have different conversations each time. This is a topic near and dear to my heart as an IP lawyer by background originally. I think this is very important. And I know that there are so many questions that I've gotten over the years from founders in the Fourth Effect about patent strategy, IP strategy generally, especially as a tech startup. And then especially in the age of AI, this has been coming up a lot. It's super interesting. So with that, I'm so excited to introduce our guest of honor today, Alex Franco. And he is a very experienced IP lawyer, has great experience both in-house at IBM and then also, working at outside GC as a partner for a while now, and is my colleague at outside GC, where I am also a partner in that law firm. And Alex and I have had this conversation a couple of times of just, wow, we have all these startups. I just know kind of a patent strategy 101 would be so incredibly helpful. And, having the ability to just ask questions and figure out, where is there a kind of, offensive benefit to thinking about IP strategy? When is it maybe there's some defensive concerns that someone might have in terms of like bolstering, retaining, keeping everything safe as the founder. There's all sorts of interesting things to talk about here. So glad to have you, Alex. And with that, let me turn it over to you to more properly introduce yourself. And then I know that this is something you speak about frequently. So you have, you have some thoughts about how you want to dive in and get us started. And then Tino and Eugene, if we remain this small, this is super intimate, any and all questions you have. I have a whole list of questions that are my questions and also based on questions I've heard from founders in the Fourth Effect. You both might have your own specific questions. So please feel free to, probably best, since if we remain this small, is just unmute yourself and ask when Alex is open to them. And then I can ask my questions too. And then this becomes a really great resource as well. In our resource library for founders, we'll try and cover a lot of ground. So that this can be a great resource for those who aren't here today.
Yeah, well, thank you so much, Breen. Appreciate that introduction, and nice to meet you, gentlemen. One thing that we can do is it's fairly convenient to have a group this small because we can tailor the subject matter and the conversation really to questions that are of interest to you guys, and we can adapt this to the level of experience or understanding you may already have about intellectual property and more specifically patents today. So, I do have a patents 101 presentation which we can go through, and probably we might spend, if we want to do that, a good 30, 45 minutes, maybe a little bit more, depending upon how quickly we go, going through patents really from start to finish, assuming you don't know anything. Now, it may be the case that you do have some experience in patents, in which case we can start out at a little bit higher level. So it might be helpful to get some feedback from you guys as to the level of experience you have in the patent space. For example, have you ever been through the patent filing process? Or are patents a completely new concept to you? And let me just jump out with that first. So Eugene and Tino, let me know what, if anything, you know about patents and intellectual property.
So know a little bit. So I'm actually working on a AI, ML, natural language processing type technology and healthcare data and clinical trials. So I'm not working on a therapeutic. As I've been involved in situations where there was, IP, university type IP for therapeutics or diagnostics, which have many years on them. This particular project, there is some IP at a hospital organization, Memorial Sloan Kettering, but the use cases and that we might actually be working on might be different. So it's I'm coming at it from a data, more of a data type digital healthcare kind of application as opposed to a therapeutic with that kind of IP.
And that's for me, it's helpful because one thing that I do not do is the therapeutic side. Anything in the pharma space or chemical spaces outside of my scope of expertise. I have a degree in applied physics and computer science. So anything except for chemical and pharma is stuff I can handle. But that if it's in that space, I bounce it to somebody else. Have you ever been through the patent application filing process?
So I've really been more of a recipient. Working on university type technologies where already there were patent filings.
Yeah, got it.
And then kind of thinking through some of the issues as opposed to from day one. So.
All right, that's helpful to know. So it may be useful to actually do some of this patents 101. And Tino?
Yeah, so we have a patent and a continuation in part approved. It attached to the first patent because the claims were similar. And the patent is on the software and process of custom manufacturing using AR and VR as that user front end. The idea behind it was if you could translate what someone is imagining into machine manufacturing instructions, then you could create a WYSIWYG type of system for manufacturing. And we surprisingly, 3 years and $12,000 later, we had it issued. And the continuation in part is for the same technology, but to be used for medical implants explicitly. So modify a hard manufactured good into a patient specific product.
Okay, interesting. And did you say using AI or AR?
Augmented and virtual.
Okay, augmented reality and virtual reality is what you're saying. Okay, yeah, got it. Yeah, because I know we've talked a lot about the use of AI, which is another thing that may come into play in these spaces. Like they're doing a lot of generative AI when it comes to manufacturing. So that's I wasn't quite sure if that was it, but you are well down the road of understanding patents 101 is probably not something that you're going to get as much out of. That may be more useful for Eugene. So what we may want to do is kind of jump in
and Alex, just to very quickly interrupt you, I also am thinking about this for the fourth effect.
Yeah.
And even though, yes, my background is in IP, it was soft IP, so copyright and trademark.
Right.
And also that was a while ago. So I did that first, then I went in-house general counsel for tech companies. So, so I'm very fuzzy on my knowledge. And I can tell you that, we just took on a CTO and we have a whole lot that we're working on. It's all very agentic AI driven, but long story short, what I really hope to be able to do is to essentially have every startup that comes in that we equip and incentivize to create a fit for purpose advisory board and governing board by looking to all the data that is known today and all the benchmarks that we can find looking at other startups. We want to be able to make these insightful recommendations to startups, and then we're monitoring and watching as they add advisors, as they get ROI and value from these boards as they scale. And so our AI gets smarter and smarter and smarter. And so ultimately the goal is at scale, we would become the expert. Like we would have insights and benchmarks and the ability to predict and guide scaling companies, regardless of industry, and very idiosyncratic to exactly what that startup is facing. That ultimately is our goal with our AI. So is there anything in there that is patentable that we should be thinking about that? Because we're about to also fundraise in earnest, to help us too with some of this build out. And would that help us in our strategy?
Yeah. And you're talking about the fourth effect particularly.
Yeah.
Yeah, there. And that kind of gets into the question of trade secret versus patent. And are you better off if you have models that you're preparing and training, maintaining that as a trade secret, as opposed to, it may be the case that what you're doing is really so public that there conceivably could be some benefit to going the patent route, because you have little to give up when it comes to your trade secret, if there is one. So, it's a fair question. When it comes to patentability, is this something you can conceivably put down in a patent claim, or is it going to be a little bit too abstract for the patent office to allow at the level of detail that we're trying to describe it? So that's an open question these days. So, and I'd say that's something we probably want to talk about, offline, particularly with respect to your particular situation and what might be inventive concept, that leverages AI. So yeah, it's a space. Yeah, go ahead.
Yeah, I'm also interested in AI because so we have a distributed manufacturing network. So it's not only do we have the patent, but also our core. We sell custom cabinetry, simple. But because we're also generative design ready, where someone can go to as long as the design tool is using our library of products, it can go from a Gen AI design, I like that, and hit, and then pay for it and receive it within a few weeks.
Mm-hmm.
So I'd like to understand how our business and the trade secrets and operational whatevers that we have as our internal moat bridges into AI and gen design, and is there anything that we can protect aside from our core library?
So this is the Breen had sent me some questions in advance, and I think this is,
and just saying trade secret. Yeah, the whole trade secret issue, that's clearly an issue for us too.
Yeah. So yeah, I think Breen, you had kind of touched on this, and I think I've got a slide on it, but we're talking about it just more abstractly now and generically. So one question is, can we protect AI related inventions? Mm-hmm. So there are two ways to look at this. One is AI a component of the inventive process itself? Meaning, are we patenting a process that leverages AI? Not a problem there. Where we do have problems in terms of patenting is if the results of the invention are AI generated, meaning the invention that we see. So for example, a good example is, let's suppose we're trying to protect a design itself with a design registration or a design patent. It might be a tool, an object, a widget, a car part. That car part, for example, is completely fabricated, generated by generative AI or a cabinetry layout, whatever it may be. The problem here is in trying to protect that. The general status of the law today is anything completely generated by AI cannot be protected with patent, copyright. Trade secret's a whole nother question, but patent or copyright are not going to be an option. Or design registration may be different in other countries, but not in the US. And the reason is we always have to list a human inventor. Mm. So a generative AI design or produced design, if it's not based primarily upon the work of a human being, is not going to be eligible for patent, design registration, or even copyright protection. So distinguish one where maybe we have a design where a human leverages AI to do some generative work, but the real core substance, the majority of it, is going to be the work product of that human. Maybe they applied some generative AI to apply a pattern over the design that they've otherwise created, or they've really done a lot of work in guiding the generative AI with prompts. So it might be a fuzzy line here, but how much of the work is ultimately done by a human? And if really we can say the inventor is a human, we're going to be eligible. If the majority of the work, for all practical purposes, was done by machine, there is no human to list as an inventor. So this is a debatable issue, and the line might be fuzzy between the two. But that is ultimately the answer to the question. Now, that's a different question of whether we want to patent a process where using generative AI is part of that process. So step A, gather the information, put this through an AI, generative model, come up with a result. Well, the process of using AI is certainly, we can patent. That's a process that was it was conceived of by a human being. How to use AI, rather than the product itself of the AI. Is this making sense?
Can I think it is. And can I just ask you a clarifying question just to make sure I'm understanding you correctly?
Right.
Okay. So in our case, the process might be that we are gathering all that is known today about for-profit advisory boards, for instance, and we're gathering it in one place, in one notebook or mechanism, and then we are, creating this RAG system, and we're creating all these prompts, and we're going to direct AI to take action based on, to draw into this information that we have gathered, and then, it takes some action and then spits out a result, like in our case, like insights or, a product. And that process would be the thing that we might be able to patent, but not the insights that get spit out.
Exactly. So
Okay.
the process is something that you guys came up with. This is a design that, you guys fabricated, conceived of, and we can describe this process in a patent application and maybe get a issued patent with a claim covering it. But the actual output of it, assuming the output is completely AI generated, would not be something you could protect with copyright, or patent or design. The design or the patent probably wouldn't be applicable. And I don't know why you'd want to, because each individual result that you get out of this process in itself is not going to be something you want to protect. That's, that's your work product day to day and, and hour to hour. So it's really the overall process. You want to prevent using intellectual property and its, exclusionary functionality. You want to exclude others from being able to do that same process.
Yes.
Now, if they come up with a result using a different process, that's not something we can seek to prevent. But using your process, you want to essentially foreclose competitors from duplicating, ripping off, or otherwise, leveraging the process that you came up with. And that is where a utility patent would likely come into play.
Interesting.
So,
and at the risk of dominating, can I ask one more question? That was very clear. But one thing I wonder is, okay, say skip ahead, if we were operating this at scale and we were essentially teaching ourselves, like if you think about what is known right now about advisory boards, it's a tiny little percentage. I would say it's 5%, and 95% is unknown. But if we had thousands and then tens of thousands and then millions of startups all coming in, and we were learning from every single one, and our AI was constantly putting all those insights and information back onto the board, if 5 years from now, instead of that being 5% that's known about advisory boards, now it's 95% that's known about advisory boards, would we own that? Would we own the wall? Would we own that knowledge?
So what I think you're getting at is you would then have trained a model based upon a bunch of data that you had gathered, right? And the value there is going to be in the trained model itself, all essentially the variables and the data that
Okay.
make that trained model successfully. You basically incorporated all this model, all this information into your model by having the model ingest all this data. You know, just like ChatGPT digests everything in the internet. All right, as of a year ago, and of course, you know, it's more recent versions. They keep updating it, but they have a great trained model. The value there is essentially a trade secret with the variables of that trained model that they've ingested into it. Now, they don't publish that. Now, on the other hand, you have the Chinese competitor. What is it? Remind me, guys. What is it?
DeepSeek.
DeepSeek, exactly. Right. So they've trained a model that they then distribute for people, but the actual the details of that model are something they retain as a trade secret. Right?
So helpful. I hope it was also helpful, Tino and Eugene, for you guys, not just me, but okay, super helpful to understand that. Thank you.
So, you know, that's where, you know, we divide between what you can, you're not going to protect the actual trained model, but but what you can protect with patents is the process of training and using the model at a more generic level. Right? So nobody's going to, you know, if somebody literally goes in, breaks into your servers and steals your model, that would be, you know, trade secret theft or just general theft. I mean, probably a copyright violation because it's your, you know, your model that you might have created. But you know, we're more concerned about somebody who's independently replicated the same process and trained their own model based upon their own data. And that's where we protect with patent. So with that, one thing I would like to mention, and this is what I do in the Patents 101. If we want to, and we can jump to that if you guys are interested. Tino, it might be a little less interesting for you because I do start from the ground up. But things that oftentimes startups might want to think about is the option of design patents and international design registration, which is a whole nother parallel track to utility patents, which is what we can typically think of, you know, like the Edison patent on light bulb or Bell patent on telephone. You know, it's a lot less expensive, and when it comes to startups that are actually in the, you know, consumer product space or gadgets, whatever it might be, if you're actually creating something physical, that is a great option. Eugene, probably not applicable. Tino, maybe not, but it's definitely, you know, something to think about. Tino, you were saying custom cabinetry. Did I understand? I heard that, and then I heard there was another aspect to what you're doing. But is that the core of your business, custom cabinetry layout?
We've reinvented manufacturing supply chains. So we've digitized the entire thing from order until machine instructions, and then we distribute the manufacturing instructions and materials to a network of local manufacturers. So we're the Airbnb / Uber / DoorDash of custom manufacturing, and our beachhead is cabinetry because it's a $100 billion super inefficient industry.
Yeah.
You know, part of my interest in this conversation is how do we treat the data pool that we're going to be creating? Because the data pool, as we accumulate transactional data, as we scrape it off the internet, we'll be able to price more effectively, cost optimize more effectively, and etc. And so, is that just an internal trade secret that we're?
Absolutely, yeah. That the best way to view that would be an internal trade secret. That and just to talk a little bit about trade secret is any information that has economic value to a company that the company takes reasonable steps to maintain in confidence. Now you can do that with policy, also by contract, but that is what a trade secret is. And it's the nice thing about it. There are no official steps. There's no filings you have to make. It's not costly. And it's not limited in terms of its duration or term, whereas patents and even design registrations all have a limited duration. So something to think about. But yes, that's the answer to your question. So if you're gathering data, training models, that's really all part of your company's internal trade secret technology.
Okay, thank you.
So with that, we can go in any direction right now. Breen, we can jump to, for example, some of the questions that you had sent to me earlier. We can jump into that Patents 101. Let me see if we can get a consensus here. As you know, we're about a half hour in to our 1 hour roundtable. So let me know what you guys think would be helpful.
Though I'm sure your Patents 101 is far better than any others that you could see on the internet. There are others.
Yeah, so, exactly. Yeah. But it is certainly something that I'm trying to think if I've seen a good Patents 101 on YouTube. I've seen live Patents 101s that are decent. Of course, I view mine as better, but that's how things go. And of course, then we have, Breen's question. Why don't we jump in? Let me make a suggestion. Why don't we jump into Breen's questions? Because I think that that focuses on some of the, obviously the burning questions that Breen has seen come up again and again for people like you or startups that she deals with. So let me see if I can fire up my presentation here, in which I've incorporated some of these questions. So bear with me.
Amazing.
And I'm gonna fire up a PowerPoint and then somehow start my Zoom sharing. Let's see here. Okay, share a window. No, an entire screen. Here we go. Okay. So let me know if I am sharing. I think
you are indeed. You are indeed.
Okay, that's me, of course, better and younger looking me. And let's start with this, because I think this has some value. Tino, I'm not sure if this is something you did, but it sounds like you're way down the road. You mentioned something about $12,000 to get a patent, if I understand that correctly, from start all the way through issuance and then file a continuation in part. If that's accurate, you're doing well. You're dealing with a patent attorney who's working efficiently. Did I get that right?
Yeah, I love my patent attorney, and I did a lot of the legwork, right?
Yeah.
Initially, and I discovered that there was something there, and and so the whole point is but he is efficient, and I mean, even on the original filing, he added one word that just transformed the whole thing into this huge umbrella.
Yeah, and that's why you want to have a good patent attorney. It may be as simple as one word or just one thing you might have missed not being a patent attorney that a skilled patent attorney can bring to the table that can completely change the game. Now, one thing I'm curious whether you or they did is file provisional patent applications, or did you jump right into filing a utility patent application?
Yeah, we filed it. I wrote the provisional. He reviewed it and redrafted it, and then so that was a $400 process, and gave us an extra year. Absolutely.
Exactly. So you did go the provisional route, and that is absolutely what I recommend for startups. So Breen, take this as the advice that I would give to anybody in a startup situation. And Eugene, are you familiar with provisional patent applications and how they work?
A little bit.
A little bit. So, and this I'll touch on if we get to the Patents 101. But the short of it is, a provisional patent application, Tino's obviously gone through the process, so he understands it. But a provisional application is essentially an informal filing of pretty much anything that you can assemble into a PDF document that we send into the patent office, and they basically date stamp it with, hey, we received this on this date. It demonstrates your possession of anything that's in that PDF. It might be an invention, who knows what. The point is, though, we can go back until up to a year later and file a formal utility patent application that can ultimately issue as a patent and has all the requirements of a formal patent application, but refers back to and we say claims priority to the provisional. And if the concepts that you're seeking to patent were fully disclosed and supported in that PDF, the original provisional patent application PDF document, then you will be entitled to that earlier filing date, up to 1 year earlier, of that provisional patent application. So it allows you to put your stake in the ground, and the patent system is a first to file system. So if somebody else is inventing at the same time, you want to be the first one to the patent office. And this allows you to put your stake in the ground and demonstrate possession of that concept earlier than somebody else who might also be running to the patent office, or somebody else who might publish a paper or release a product after your provisional filing. So it allows you potentially very inexpensively, and I think Tino made this point, I don't know, was it for $400 or something like that, basically the filing fees and not much attorney time, to get something unfiled at patent office. And we can file provisionals for, in the range of $400 up to several $1,000s or more, because we have a lot of flexibility with provisional applications. We can do anything from, listen, whatever you give me, I put a cover sheet on it and send it into the patent office. If you have a very low budget, we can go anywhere from that all the way up to preparing a complete informal utility patent application, which for strategic reasons, we may actually want to file as a provisional instead of a utility. And one of the reasons I think Tino mentioned is it pushes off your patent term for 1 year into the future. So ultimately, the patent that you get will expire 1 year later. Now we're talking 20 years out. It's a long time, but your patent will ultimately expire a year later, 20 years from now, than had you not gone the provisional route. Even though you had filed the same application, you decided to formalize your patent application and file it as a provisional instead of a utility. Now, maybe a little bit abstract, and I'm jumping into some of the details of how patents work and in patent terms of 20 years. But the short of it is, I highly recommend leveraging provisional patent applications because they can be done quickly, easily, at a low cost, and oftentimes we can take content that is completely generated by the inventors or the company with very little attorney time and get a filing date. Some people try to file their own provisionals. I don't recommend that, largely because there are so many stupid things that can happen. I've seen situations where people forget to pay the filing fee. They don't properly register, and what could have been a valuable filing turns out to be a mess, just because they wanted to save, let's say, 1 hour of attorney time. It's well worth it. If all you want to do is make sure you get that provisional in file, leverage your attorney, tell them, hey, listen, we've got a very low budget for this. Get it on file for us, track it, and we'll then come back in a year and figure out what we want to do. So my recommendation is leverage provisionals early and often. Work with your attorney. If you have a budget, you can certainly set a moderate budget. For more important subject matter, you may want to spend a little bit of money having your attorney do some substantive review. One of the most valuable things an attorney can do in the context of filing provisional applications is actually write and add claims to that provisional. So Tino, just out of curiosity, I think Tino, is he still with us? He's left. One of the things that you can do in a provisional is actually write those claims, file them with the provisional, so that 1 year later, those claims, you have definite support. And the claims are really the legal definition of the invention. So that's really the meat and potatoes of what a patent attorney does. Writing those claims is the most crucial aspect. One of the other benefits of the provisional is oftentimes you have a lot of ideas early on, and over that course of that year, you may realize, oh yeah, those ideas are not going to work, and they become obsolete. They're no longer of interest to you. Had you spent a lot of money filing utility applications out of the gate, you might then realize a year later you wasted a lot of your money and time and effort. So leveraging these provisional patent applications gives you a lot more flexibility, saves you a lot of money, and frankly, you can probably file, could be 5 to 10 provisional applications for the cost of one utility patent application, just depending upon how extensively you want to work them, or how carefully you want to have your patent attorney work on them. So,
and the issue there also is, right, you're making a presentation, and maybe you're going to divulge something that might be confidential. So the best thing is, don't avoid any prior art issues. File it.
Yes, and so one of the nice things, another thing about provisionals is, until and unless you file that formal utility patent application claiming priority to and referring to the provisional, that provisional stays confidential in the patent office. It's not published. Distinguish this from a utility patent application, which does publish after 18 months, 18 months after the very first date you claim, which can include the date of the provisional. So a typical scenario is you file your provisional, let's say on January 1st of year 1. You then file your utility on January 1st of year 2, and then 6 months later, on July 1st of year 2, the utility application publishes, and then the provisional patent application becomes accessible to the public on the Patent Office website if searched for. You can, however, a caveat here is, if you do not plan on pursuing international protection, and that is the last point I have on this slide right now, if you're not going to pursue international protection, you can make a request to the Patent Office for non-publication. So you can say, I promise I'm not going to file this internationally, because internationally, generally applications are published. But if you're not going to file internationally, you can make a non-publication request with your utility application, and the Patent Office will keep that application confidential and not publish it until and unless it issues as a patent. Now, obviously, a patent to issue, it's a public document. So that is a way to what you can do is, if you have something you're debating, keeping as a trade secret, or you might want to patent it, you can actually file a patent application on it, request non-publication, and keep both of your options open until you get to the point where the Patent Office is ready to grant your patent, and then you decide, okay, which one would I rather have? Do I want to keep this as a trade secret, or are these claims interesting enough or broad enough that I'd rather have the patent, or am I worried about other people competing with me, and it looks like they're starting to do the same thing? I may need that patent because the trade secret looks like it's no longer of value. Other people have figured this out as well. So you can kind of delay that decision by filing a patent application and requesting non-publication.
And how long can you delay that decision? Just the 1 year?
So you can kind of delay it indefinitely. So let's suppose you file the provisional. Remember, the provisional is not published, okay, until you claim priority to it in an application that doesn't request non-publication. So we can file our utility January 1st of year 1, you file your provisional January 1st of year 1, file your utility January 1st of year 2, requesting non-publication.
Mm-hmm.
That patent application may sit in the Patent Office for years.
Mm-hmm.
You may go back and forth with the examiner because you're not happy with the claims, or they're rejecting your claims. Or maybe you get to the point where they say, oh, your claims are allowable, you can have a patent. You can then say, oh, well, I'm not quite ready yet. I'd like to file some additional claims, all right? Or I'd like to pursue a continuation. For all practical purposes, you could keep that patent application pending in the Patent Office for as long as you want. It does get a little bit costly the further into the future you go, because they're filing fees for the additional applications. But conceivably, and they used to call these submarine patents decades ago before the law changed. But you can keep that patent application pending in the patent office for many years, but in no case can you go beyond the 20-year patent term.
Mm-hmm.
Okay, because the patent term, you can't have a patent that extends beyond 20 years. It used to be the case decades ago that a patent term was actually determined by 17 years from the date a patent issued, rather than 20 years from the date it was filed. And we had something called submarine patents. And what people would do is, back in the 50s, the guy who first invented barcodes filed a bunch of patent applications and then kept them pending in the patent office for a very long time. And patents were issuing 20 years and even 25 years later that then had a 17-year patent term. So he was getting protection on things for which he had originally filed 40 years prior.
Wow.
And that's the idea of the submarine patent. It comes back to haunt people many years later. So internationally...
Wait, and that's how long it took anyone else to figure out the barcode? So like it was still...
Oh, no. People were doing barcodes. The point was that this guy who had filed an early patent application used the processes of the patent system to keep his monopoly active for much longer than 20 years. And there were lots of lawsuits and debates, trying to invalidate these patents, but the law changed because we realized this is not fair to others to allow somebody to extend their monopoly past those.
Sorry.
Go ahead.
I guess the point that the reason why I was confused is because I thought if it wasn't published, then the barcode guy would not have been able to use it, offensively or defensively. But that's not the case. Like, just because it's unpublished doesn't mean you can't.
Well, what happened with the barcode patents is an initial patent was granted, but then they filed something called a continuation and more continuations. So this was irrespective of publication. The patents were published, but the patent owner went back to the patent office many times to get additional patents.
Okay.
And because the law was different at the time, the term of those patents was not limited to 20 years from the date of filing.
Right.
So they were filing patent applications 20 years later after the original patent application. And then those patents would grant and give them yet another 17-year term.
Okay.
So you had a series of patents that issued starting maybe 3 years after the initial filing, went for another 17 years, but then there were other patents based upon that very initial filing that persisted yet another 17 years after the 20 years. So you had protection that existed for in the range of 40 years. And that, you can look up the barcode patents and essentially what happened. But they changed the law because of that. It just is not fair. The quid pro quo of, if you want to have an exclusive monopoly, you've got to exchange with the public the knowledge of your invention for the limited duration monopoly. That breaks down when that monopoly is no longer a limited duration. And that's why they changed the law. And it said, you get 20 years from the date you first file, and that's it. And if you want to pursue continuations, that's fine. But if you pursue a continuation in year 15 and the patent issues in year 17, you only get 3 years of exclusivity.
Right. Okay. No, thank you for that.
All right. So with that, let's see if I can, this is the last point on my slide here is international protection is expensive for utility patents. If you're doing designs, they're very reasonable ways to get broad international protection. But if you're in the AI space, and AI is a part of your process, to the outputs being what you want to protect. But if they want to protect the process, international patenting is not something I'm recommending generally for the startup space. Save that for when your business is up and running, you're funded, you're actually making money, you've got a revenue stream, and you're building your patent portfolio and you're concerned about competitors in other countries. If you're starting up, you're just concerned about surviving, hopefully just in the United States. Once you get past that very big hurdle, then you can worry about international patenting 3, 4, 5, 6, maybe even 10 years from now. But it is preclusively expensive otherwise. So with that, let me see if, yeah, I do have some of the questions, Breen, that you had posed to me. And I think we have about 12 minutes left in the hour. So, I'm happy to address those. And I've literally kind of typed out some answers here to your questions, but you group them: strategy and business impact. Question: what is the best way to align my IP strategy with our business goals and funding timeline? Well, I mentioned provisional patent applications. That is a great thing to do. Leverage those provisional applications to delay and possibly even avoid costly utility patent application filings. And I think I mentioned this again. Your future decisions with hindsight are going to be much better informed than your present decisions. So running out there trying to protect everything and spend money on it now, is probably not the best use of your funds. And I think this addresses also the second question: how do I build a patent portfolio that increases the company valuation, not just legal spend? Having a big portfolio of patent applications can move the needle. They roll off after a year, pick and choose the best ones, but there's no limit to the number of provisionals you can file, and you can do it relatively inexpensively. Let's go to the third question here. Which innovations are worth patenting now and which can wait? Honestly, you may not know, and that's where the hindsight comes into play. Leverage the provisionals to put your stake in the ground, and having that stake in the ground with multiple provisionals, you can then go back and see which ones ultimately have value with that 1 year of hindsight you now have under your belt. Companies evolve usually very quickly and gain a significant amount of knowledge over the course of a year. So we can push off a lot of those decisions to a year from now. Can patents help differentiate us in investor conversations, even if you're pre-revenue? Absolutely. Patents and applications can help move the needle. But one thing I caution my clients is don't expect patents to carry the day. A business founded on the idea that all we have is intellectual property, not a product, is not a good way to run a business. Patents should really be the icing on the cake, rather than the core of the business. It's a very difficult way to make money, monetizing patents. Not easy. They're better leveraged to promote what is otherwise a great product, to help deter competitors. Because oftentimes, if you do have a very broad patent out there, other competitors may or might be informed of it, and they might decide, yeah, we don't want to risk doing that. So they stay away, or they don't replicate your invention. So my point is, yes, it definitely can move the needle, but don't plan on it essentially being the main course.
And can I ask just some very obvious questions, like how long would it take? So say Eugene decided today, okay, great, I need this. I want a provisional patent, and I'm talking to investors, in June, and I want to have it by then. Like, how long of a process? How do you get rejected? Like, is there a real risk?
So let's talk a little bit about the timelines. I do have a slide on this much later here. I don't know if it's worth going to. Let's see, when to file. I'll touch on this. Hold on, examination. So here's our slide. I mentioned file your provisional, January 1st of year one. But let's suppose you're chomping at the bit, because if you file your provisional on January 1st of year one and you file your utility on January 1st of year two, you're not going to get a patent office, a response back from the patent office until about 1.5 to 2 years after you file that utility. So it could be 3 years after you file that provisional before you even hear back from the patent office. Okay, so if you're chomping at the bit, you want to know something by June, one thing you can do by June is get a bunch of provisional patent applications on file, maybe even a utility patent application. And if you want to share those under NDA with a potential investor, you can certainly do that. All right. But let's suppose you're even in a little bit different situation. Let's suppose you're ready to go to market and you're concerned about competitors ripping off your idea right now. So let me jump to something called prioritized examination. So this is an option. You want a patent as soon as humanly possible. What we can do is disclose your concept in a formal utility patent application, skip the provisional, and we can file a request for prioritized examination. For a small business, it costs an extra $2,000 in filing fees. But the patent office will pick up your patent application and start examining it within about 3 or 4 months of your filing. And you can get an issued patent in less than a year. And I've done this for a number of clients, and we have issued patents coming out 9, 10 months later after filing. There, you can we have a win very quickly. You can go out and say patented. Your competitors may see this as a deterrent to competing with you. And it can be done in a relatively quick time frame compared to other, other options in the patenting space. So this is an option for utility patents. I don't know if you have any more follow-ups on this, or we can jump back to some of the other questions we had. And
I guess one other, maybe this is really obvious, but like, is there a what if you're dead wrong? That the thing that you are seeking a provisional patent on is something that the USPTO would ever deem, to be adequately novel, or, is actually an invention.
Yeah.
What is the downside to filing that provisional patent if you can ultimately get the patent?
So when it comes to the provisional, there's really no downside except for your time and money. And with the provisional, as I mentioned, you can do that relatively inexpensively. That is why I highly recommend leveraging the provisional patent application process. You don't have to do anything with a provisional application. You can just let it go abandoned, right? It's kept confidential. So really, there's not a risk in filing that provisional patent application. I'm not sure if that is that the question that you were going at, or did I miss it?
I mean, it's like, I'm thinking about this from the perspective of, scrappy startups. They're going out and they're pitching VCs. They want to differentiate themselves from competitors. To be able to say, we have patent pending on this unique process leveraging AI to do this novel thing, that's like, I could see how that could be very compelling as a differentiator. And then I guess, like, if the bar is low, meaning like, as long, I assume it has to be good faith, right? Like, you have to have a good faith argument that you think this could be patented. Then you're not doing anything wrong by filing that application.
Yeah, there really isn't a downside to the provisional. I think the other question that I missed that you did ask is, how do you know that there's any value in the provisional? You don't. You really don't. And that's why it's nice to have that 1 year of hindsight before you spend the money on the utility. So the utility is where, it starts to cost some more money. And that is why, in some cases, you may want to conduct a patentability search. So if you're entering a new space and you're curious, who else is out there already with intellectual property in this space, we can do some searching. Now, listen, you can go and do your Google search, but one of the best sources for information about what technology is out there is actually prior patent application publications, internationally and otherwise. And there are some pretty good tools that we can use to search those. And if you're good with the query languages, you can be a lot more precise than a plain old Google search. So when I do my patent searching, I get garbage out from my Google searches. It's just not productive. And I actually use a World Intellectual Property Organization search engine called PatentScope. And it's got a very precise query language where I can tailor very, very, very precise queries to try to search for and narrow down specifically what I'm looking for, to figure out whether it's been done before, whether there's other people out there with issued patents, or whether the idea has been previously disclosed in a published patent application. So that is a potentially valuable process for a couple reasons. One is it can inform you as to whether you're just throwing money away by filing your patent application, because yeah, this has identically already been done before. Or potentially, if you are going into a space where there's a lot of investment going into this, are you potentially stepping into a minefield where there are one or more potentially dangerous patents out there?
Right.
If you can become aware of those, you may decide to change your strategy. Okay. You may decide to change your product if you become aware of patents out there that present a problem for your intended design. And you may decide, oh, shoot, yeah, we don't want to do it that way because there's an issued US patent covering exactly that. You go back to the drawing board, do a little brainstorming, and say, but there's another way we can do it. And actually, guess what? It's better. Not only that, we can patent that way.
Right.
Okay.
And with AI, what do you recommend right now? Like, do you think, like, so say someone were contemplating filing a provisional patent, potentially a utility patent eventually, that that leveraged AI in a process. Is it good to do that search first right now? Or do you think it's kind of like a rush to be first to file because there isn't that much filed that is, leveraging AI?
Yeah. So in the, if we're talking about you're just coming up with ideas, I would skip the search and file your provisionals. Let things sit for that year as you develop, and as you get ready to file that utility. You might decide you're ready to file the utility now just because it's important. But it really depends on the investment, whether you're concerned about competitors, whether you want to do that searching. I probably do it in a minority, a relatively small minority of cases. In most cases, people feel like they have enough knowledge of their industry that they don't want to search. It's not at all mandatory. I don't know that I put searching inventions in the AI space any differently than other inventions. It's more a case of whether you're cognizant of what's going on in your industry. One of the difficulties with searching AI, though, I can think of right now is just because it's such a nascent and dynamic industry, changing very quickly. Remember, patent applications don't publish until 18 months later. We're not going to know about any patent applications that were filed less than 18 months ago when we do our patent searching. So our patent searching is much, much more useful for technologies that are not so nascent and evolving as of late. So things, that conceivably could have been done 5, 10 or more years ago. But if we're highly dependent upon a very, very rapidly evolving technology, searching is not going to be as useful because we're not going to see any of those yet unpublished patent applications that have been filed less than 18 months ago, because it does take that long to publish. So I see we're at the top of our hour.
Oh, I know this. I could keep having this conversation. This is just golden. So yeah.
Listen, I'm happy to come back and do this another time. And what we may want to do, conceivably, is tee up, a dedicated Patents 101 and announce, hey, this is for people who are neophytes to the patent space. And if you want to start from the ground up, here you go. If you filed a patent before, maybe skip this one. And then conceivably we could do, maybe another focused strategy session for people who, who'd like to get more into a Q&A. But one thing that just because we're talking about AI, you posed three questions here. Here's an interesting, I do have some answers. And I've done a posting on this recently. You know, and we talked about the use of AI and what about AI is patentable. If it's part of your process, not a problem. If it's the output of AI that you're talking about, that's probably not protectable unless there's a significant human component. But on the bottom of the slide, can I use AI or an LLM to help prepare my patent application? You know, let's say you want to file a provisional. Well, you know, conceivably I could try to do all this writing myself, but that's very labor intense. And, you know, so a lot of people are out there, you know, using prompts to generate their patent applications. Mm-hmm. It can produce some useful disclosure that may, if you review it carefully, formed as the basis of, with some review, either a provisional patent application. It might even be subject matter we could incorporate it into utility. But leverage a qualified patent attorney to review that. You should also, you absolutely be reviewing it yourself. Don't take it on faith. Some companies, try to incorporate and prompt a lot of their internal business knowledge into a AI model. And then, you might be able to pull out of that model, hey, write me a patent application.
Right. Okay, so this is so good, and only because we're 3 minutes over will I shut this down. But just so you know, Alex, there were about 10 other founders, and I know most of them, and I know that they have a lot of questions about patents that had signed up for this in the platform. I'm not sure why they didn't come. We'll be sure to not only post this for founders, as we do all the founder roundtables, but I will also, we'll email them this video too, so that they can watch it. And then I love your idea. We wanted to do a patents 101. That's something we've been wanting to do. We've just been so busy, so we just didn't, but I think we should do that and post it, like, because this one, it doesn't get nearly as much kind of headline space, as when we talk about our events, because this is our monthly founder roundtable. Yeah. But let's do that one so that all the founders that just have like the basic questions, have them come to 101. And I really appreciate this. And, also, for us, the fourth effect has been super interesting and helpful. I hope this has been good for you, Eugene and Tino, and Lawrence, who just joined. Alex, by the way, is our interim CTO. So I was slacking him because I'm like, you need to come because we need to talk about this. So thank you, and really excited to have the community know that you can be a resource. Patent attorneys can be a resource. This just makes so much sense. So
happy to have been here. Yeah, thanks for inviting me. Yeah. And happy to return and come back if and when you guys are ready.
Okay, awesome.
Can I add one thing?
Oh, yeah.
Can I add one thing? Yeah. So file the provisional as soon as you're convinced that you might have something, because we beat academic conference by 3 weeks. Public disclosure of our idea. So we got the patent only because I happened to file the provisional on my birthday.
Yeah, absolutely. So you're speaking to the value of that provisional patent application process. Absolutely, I highly recommend it. Leverage a patent attorney to look it over. It can be very inexpensive and well worth avoiding potential pitfalls.
Yeah, no, I mean, I know, just speaking personally, listening to this, I didn't realize that, I didn't realize that nuance. If it's a process that's leveraging AI, which is exactly the thing that we are kind of feverishly working on behind the scenes under the hood, why wouldn't we file a provisional patent on that? Why not? Because who knows? Like, maybe this really could be a utility patent, and it just makes so much sense. So I am very excited to have that conversation with you, Alex, so that, and that's why, I wanted Lawrence to come, but just so that we can start thinking about what we're doing, and is it one or is it more, and like, why not do that? And especially if we can do it on inexpensively, get this filed. I'm excited to know of this.
All right.
So thank you.
Well, thank you guys. Thank you for your time. Pleasure speaking with you, and hopefully we'll meet again.